Good day, ladies and gentlemen. This is Dr. Frel, your professor. Hello class, good morning. We're back for our course, Law-Related Studies. And this is the second part of the discussion on the Family Code of the Philippines. We are still under Title 6, Paternity and Filiation. The first question that they're going to answer under this title is what rules govern when the marriage is terminated and the mother marries within 300 days after the former marriage is terminated. Article 168 said, if marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, the following rules govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. Now, my next question is, when should the action to impugn or question the legitimacy of a child be filed in court? To answer this class, Article 170 provides that the action to impugn the legitimacy of the child must be brought within 1 year from the knowledge of the birth or its recording in the civil register, if the husband or, in a proper case, any of his heirs should reside in the city or municipality where the birth took place or was recorded. So remember class, it will take only 1 year from the knowledge of the birth of the child or its recordings in the civil register that the legitimacy of the question can be filed. Or, class, the question as far as legitimacy of the child can be filed in court. Another class, if the husband or, in his default, all of his heirs do not reside at the place of birth as defined in the paragraph above or where it was recorded, the period shall be 2 years if they should reside in the Philippines and 3 years if abroad. So class, be reminded that what was explained earlier is if the husband or in the case of his heirs, they should reside in the city or municipality where the birth took place or where the birth was being recorded. Now, in cases where the husband or his heirs do not reside at the place of birth or the place where it was recorded, the period of 2 years shall be given. That is, if they reside in the Philippines, and 3 years if they reside abroad. Now, it was provided further class that if the birth of the child has been concealed from or was unknown to the husband or his heirs, the period must be counted from the discovery or the knowledge of the birth of the child or of the fact of the registration of the said birth, or whichever is earlier. So the same number of years shall be used class if they reside in the same place or within the country or if they are abroad. Now, the next question class is, in what instances can the heirs of a husband question the filiations of an alleged child? In answer to that, Article 171 provides that the heirs of a husband may question or impugn the filiations of the child within the period prescribed in the preceding article only in the following cases. Number 1, if the husband should die before the expiration of the period fixed for bringing his action. That is either 1 year, 2 years, or 3 years. Second, if he should die after the filing of the complaint without having desisted therefrom. And third is if the child was born after the death of the husband. Now, class, you might ask, how can the filiation of legitimate children and or of illegitimate children be proved? So, the same code provides that the filiation of legitimate children is established by any of the following that is found under Article 172. Number 1, the record of birth appearing in the civil register or a final judgment. Number 2, an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. Now, class, how about in the absence of those aforementioned evidences? What will be the proof of the legitimate filiation of the child? So, Article 172 continues. Number 1, the open and continuous possession of the status of a legitimate child. And number 2, any other means allowed by the rules of court and of special laws. Okay, class, so those are answers to question as far as legitimacy of the child is concerned. Now, let's discuss the rights of legitimate children. The first right is to bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames. So, class, legitimate children have the right to bear the surnames of their father and or their mother. Number 2, to receive support from their parents, their ascendants, and in proper cases, their brothers and sisters in conformity with the provisions of this code on support. So, class, what was mandated to support the children or the legitimate children are their parents in or their ascendants. But there are also cases where brothers and sisters are obliged to support as long as it is in conformity with provisions of the code on support. And third is to be entitled to legitime in other successional rights granted to them by the Civil Code. These are all provided, class, under Article 174. When we say legitime, class, this is also known as the forced share or the legal right share of a decedent's estate in that portion of the state from which he cannot disinherit his children or his parents without sufficient legal cause. Plus, this legitime is that fraction of the decedent's gross estate and that is being passed as a joint property to the decedent's next of kin in equal undivided shares. Now, the next question, class, is who are illegitimate children? Under Article 165, Chapter 1 of Title 6, illegitimate children are those children conceived and born outside a valid marriage. And the next question, class, is how can illegitimate children establish their filiation? The law provides that illegitimate children may establish their filiation or relationship with their biological parent in the same way and on the same evidence as legitimate children. Now, class, let's proceed with Title 7 of the Family Code that talks about adoption. But before we discuss the provision of the law, we have to define adoption first. Adoption is a process whereby a person assumes the parenting of another, usually of a child, from that person's biological or legal parent or parents. Legal adoptions permanently transfer all rights and responsibilities along with filiation from the biological parent or parents. So Article 183 of the Code provides that a person of age in a position of full civil capacity and legal rights may adopt. But it has also another provision that only minors may be adopted. When we say a minor class, it is a person under a certain age, usually the age of majority, which is in the Philippines is the age of majority is 18 years old. Now the next question is, who are those persons not allowed by law to adopt? So under Article 184, it provides that the guardian with respect to the ward prior to the approval of the final accounts rendered upon the termination of their guardianship relation. And any person who has been convicted of a crime involving moral turpitude. When you say moral turpitude class, this is an act or behavior that gravely violates the sentiment or the accepted standard of the community. Third, an alien is not allowed to adopt also, except former Filipino citizen who seeks to adopt a relative by consanguinity. When we say consanguinity class, that is a relationship by blood or by blood relation, meaning we are of the same kinship as another person. Then another exception is one who seeks to adopt the legitimate child of his or her Filipino spouse. And third is one who is married to a Filipino citizen and seeks to adopt jointly with his or her spouse. Now the next question, class, is who are those persons who may not be adopted? So under Article 187, it was provided, first, a person of legal age unless he or she is a child by nature of the adopter or his or her spouse, or prior to the adoption, said person had been consistently considered and treated by the adopter as his or her own child during minority. So remember class, a person of legal age is no longer allowed to be adopted unless he or she is a child by nature of the adopter or his or her spouse. Second, an alien with whose government the Republic of the Philippines has no diplomatic relations. So if the government do not have diplomatic relation with the country from which that alien comes from, that person is not allowed to adopt under our own laws. Or rather, class, that alien may not be allowed to be adopted under our laws. And third, a person who has already been adopted unless such adoption has been previously revoked or rescinded. Now, when the written consent in the adoption shall be necessary, Article 188 provides that the person to be adopted, if 10 years of age or over, a written consent is or shall be necessary. Second, if the parents by nature of the child or the legal guardian or the proper government instrumentality. Third, the legitimate and adopted children 10 years of age or over of the adopting parents. And fourth, the illegitimate children 10 years of age or over And number 5, the spouse, if any of the person adopting or to be adopted. And class, the last subtopic for this presentation is Title 7 of the Code, Support. So, the first is we have to define support. Under Article 194 of the Code, it provides that support comprises everything indispensable for the sustenance, dwelling, clothing, medical assistance, education, and transportation in keeping with the financial capacity of the family. Another word for indispensable class, it means crucial or vital, no, for the sustenance, no, or for the survival of the family, their dwelling, their clothing, or medical assistance. This even includes no education and transportation. But of course, class, it has to consider the financial capacity of the family. Now, my next question is who are or who is obliged to support the family? So, Article 195 provides that the spouses are obliged to support the family. Number 2, the legitimate ascendants and or descendants of the family. And number 3, the parents and their legitimate children and the legitimate and illegitimate children of the latter. Fourth are the parents and their illegitimate children and the legitimate and illegitimate children of the latter. And number 5, legitimate brothers and sisters, whether of full or half blood. So these are individuals class which are obliged by law to support the family or our family. So first and foremost class are the spouses or the husband and the wife. They are obliged by law to support their family. And added to that are their legitimate ascendants and descendants, or their parents and their legitimate children, the legitimate and illegitimate children of their children. That would be all class for the second part of the discussion on the Family Code of the Philippines. And for your activity, make a pledge to your family. In your pledge, consider the major role played by your parents in raising your family. Present your pledge in any of the following: a song, a poem, a card, a painting, a letter, or any form that you are comfortable with. Submit your output in the Google Classroom, and you have 1 week to prepare your output. Again, class, this is your professor saying thank you for watching this video. See you in the next presentation.